We have a massive development in the fight against concealed carry bans, and there's a critical Supreme Court case that could reshape gun rights across the nation. The justices are set to consider this case next week, and the implications are huge. Hit that subscribe button right now, because what I'm about to reveal will change everything you thought you knew about concealed carry rights in America. If you live in states like New York, California, Hawaii, or New Jersey, you need to pay close attention to what's happening right now. These states have been aggressively trying to ban concealed carry, and this Supreme Court case could be the key to stopping them in their tracks. The case we're talking about is Wolford versus Lopez out of Hawaii, and it's currently seeking emergency intervention from the Supreme Court. This legal battle centers around a preliminary injunction and a shocking ruling from the Ninth Circuit Court that basically said states can implement sweeping property bans under the Second Amendment. But here's where things get really interesting. The Trump Department of Justice, under Attorney General Pam Bondi, just stepped into this fight in a big way. The Trump DOJ filed a powerful amicus brief with the Supreme Court, and their message was crystal clear. It's time for the highest court in the land to review these carry bans and address how states have been openly defying the Bruen decision. This is a game-changing development that nobody saw coming. The case is scheduled for Supreme Court conference next week, and just recently the plaintiffs submitted additional evidence to the court showing how other circuit courts have ruled on similar state carry bans. This new information proves there's a major split between the circuits, which gives the Supreme Court even more reason to step in and settle this issue once and for all. Let me break down exactly what this case is about. After the Supreme Court's landmark Bruen decision, Hawaii scrambled to pass new concealed carry laws specifically designed to work around that ruling. These laws were so restrictive that gun rights advocates, along with Second Amendment organizations, immediately sued the state to strike them down. When the case first went to federal district court, the judge issued a temporary restraining order against Hawaii's law. That restraining order was then converted into a preliminary injunction, which meant Hawaii couldn't enforce their restrictive concealed carry rules while the case moved through the courts. But then Hawaii appealed to the Ninth Circuit Court of Appeals, and this is where things went completely off the rails. The Ninth Circuit not only upheld Hawaii's catch-all property ban, but actually reversed the lower court's injunction that was protecting Mr. Wolford's rights. The Ninth Circuit judges tried to justify this outrageous decision by pointing to old historical restrictions on hunting on private property, claiming there was some kind of historical tradition that supported statewide concealed carry bans. This backwards reasoning is exactly what led to the emergency petition to the Supreme Court, because the Ninth Circuit's decision flies in the face of everything Bruen established about our constitutional rights. Now, I'll be honest with you, this case faces some real challenges in getting Supreme Court review. The case is still at the preliminary injunction stage, which lawyers call an interlocutory posture, and the Supreme Court typically doesn't like to review cases at this early stage. They usually prefer to wait until there's a final ruling from the lower courts. However, the fact that the United States government and the Trump DOJ are now backing this challenge completely changes the game. When the federal government files an amicus brief supporting a case, the Supreme Court takes notice and it significantly increases the chances of getting review. The government's amicus brief pulls no punches. It states that Hawaii's near-complete ban is flatly inconsistent with Bruen and the long history underlying it. The brief reminds the court that Bruen recognized ordinary law-abiding citizens have a fundamental right to publicly carry arms for self-defense. The Trump administration is pushing hard for the Supreme Court to review this case immediately instead of letting it work its way through the lower courts for years. Here's where Hawaii really shot themselves in the foot. The Trump administration pointed out that during the Ninth Circuit proceedings, Hawaii argued that there was nothing else the lower court needed to develop at trial and that no additional evidence was required. In other words, Hawaii told the Ninth Circuit that the case was ready for a final decision based on the existing record. But now that this case is headed to the Supreme Court, Hawaii has completely changed their tune. Like most anti-gun states do when they're losing, they're arguing that the case is too early for review, that there's no circuit split on these issues, and that the case needs to be sent back down to the lower courts for more factual development and evidence gathering. This is a complete contradiction of what Hawaii argued just months ago at the Ninth Circuit level. Both the Wolford plaintiffs and the United States government called out this hypocrisy in their briefs to the Supreme Court. You can't tell one court that no additional evidence is needed and then turn around and tell the Supreme Court the opposite just because you don't like how things are going. Hawaii also tried to argue that there's no circuit split on these issues, which would be another reason for the Supreme Court to deny review. But the Wolford plaintiffs just submitted a supplemental brief that completely destroys this argument. They pointed to a recent Third Circuit decision in a case called Coons that directly contradicts what the Ninth Circuit ruled in this Hawaii case. This new ruling creates the exact kind of circuit split that demands Supreme Court intervention. In their supplemental brief, the plaintiffs explain that the Third Circuit's decision in Coons deepens the circuit split in the private property default rule. The Third Circuit was reviewing a New Jersey law that was essentially identical to Hawaii's law, but they reached the complete opposite conclusion. The Third Circuit found that New Jersey's default rule presumptively banning firearms on private property was not sufficiently rooted in this nation's history and tradition to pass constitutional muster. The court explained that historical examples of such restrictions were limited to specific types of private property that were not generally open to the public, like plantations and large estates. This ruling stands in direct conflict with what the Ninth Circuit decided in the Hawaii case, and it aligns with the Second Circuit's opinion in Antoniuk. So now you have the Third Circuit and Second Circuit saying these catch-all property bans are unconstitutional, while the Ninth Circuit says they're perfectly fine. That's the definition of a circuit split. The plaintiffs argue that waiting for more appellate court decisions won't help the Supreme Court's decision-making process because the constitutional issues are already fully developed. They point out that by the time the Supreme Court would actually hear and decide this case, there will be even more circuit court decisions on identical laws from different states. And that's exactly what's happening. States across the country passed nearly identical concealed carry restrictions in response to Bruen, and these cases are making their way through various circuit courts. The results are creating a patchwork of conflicting decisions that only the Supreme Court can resolve. What's particularly encouraging is that even some of the more liberal circuit courts are striking down these sweeping carry bans. The Second and Third Circuits have both said that catch-all property bans like Hawaii's are not permissible under the Constitution. Meanwhile, the Ninth Circuit is standing alone in saying that states can implement these restrictions. With the backing of the Trump administration, Hawaii may have walked into their own trap. Their legal strategy has been focused on delay and procedural arguments rather than defending the merits of their restrictive law. They spent most of their brief arguing for more lower court development when they already conceded that wasn't necessary, and they claimed there was no circuit split when multiple circuits have now ruled against their position. The time has come for the Supreme Court to address these carry bans that were specifically designed to defy Bruen. These state laws represent a direct challenge to the Supreme Court's authority and a clear violation of our constitutional rights. This case is building serious momentum, and it's scheduled for conference on September 29th. That means next week, the 9 justices will meet privately to discuss whether they want to take up this case and issue an emergency ruling on these concealed carry bans. The Supreme Court will consider the arguments from the plaintiffs, the position of the Trump DOJ that now is the time to step in, and Hawaii's attempts to delay and avoid review. After the conference, we'll typically see the results in the following order list, where the court announces which cases they've agreed to hear and which ones they've denied. This is a critical moment for Second Amendment rights across the country. The outcome of this case could determine whether states can continue to implement sweeping carry bans in defiance of Bruen, or whether the Supreme Court will finally put a stop to these unconstitutional restrictions. We're going to be watching this closely next week, and we'll keep you updated as soon as we know what the Supreme Court decides. The implications of this case extend far beyond Hawaii. It could affect concealed carry rights in every state that's trying to ban or severely restrict our constitutional rights. If you want to support this channel and stay informed about critical Second Amendment developments like this one, make sure you subscribe and hit that notification bell. Your support helps us continue bringing you the most important legal updates that mainstream media often ignores. Thanks for watching, and we'll see you in the next video.